Good evening, dear guests and colleagues, dear Aeyal and Colleen. So it is also a very special pleasure for me to be here tonight. As Ron has already said, it's always a pleasure to celebrate a new book, even more so when the subject matter is so important, and as we all know, what can be more important than health. Third, we all know and we just heard about the very unique and broad coverage of the themes and jurisdictions, so this is a very special book. And last but not least, what can be more important than a new book by friends? So many good reasons to be here and celebrate tonight. I would like to make a few brief points with thoughts that came into my mind as I read through the book, and maybe I will allow myself also say something about relatively new cases on the Israeli Supreme Court on the right to health. Maybe this is also something I'm expected to say here today. Okay, so my first point will try to say something about the right to health in the general arena of social rights, because after all, the right to health is one very important among many social rights, and I would like to maybe to say something about social rights as the meeting point between constitutional law and administrative law, and I have to confess, indeed, these are my areas of interest. So I think that the right to health is an especially enlightening example for the challenges posed by the recognition of social rights, which have to be implemented through sophisticated bureaucratic institutions. It's not enough to recognize the right to health or any other social rights in the abstract. Indeed, the protection of the right to health is usually based on sophisticated and costly administrative arrangements. Modern medicine is dependent on infrastructure and huge investments. We just heard about the importance of the system that is in the background, as well as on the ongoing functioning of medical systems. In a similar manner, the right to education is manifested and protected through advanced education systems. Social welfare rights are operated by big welfare bureaucracies. To a large extent, the enforcement of these rights is very much dependent on public administration, and administrative law is no less important in this regard than the recognition of naked rights. At least in advanced developed countries, the operative aspect of the right to health is very far from the romantic idea of being able to get first aid and physical examination from a general practitioner. In Israel, the administrative decisions regarding the updating process of the so-called health basket and the litigation around them serve as good examples to the process of applying the right to health through administrative mechanisms. So my first point is that although we are here in celebrating the discourse of human rights, what is usually not less important is the more, I would say, everyday process, hard work on the ground. And I think that we can also see this through the case studies as presented in the book. So this is my first point. My second point touches on the connection between the right to health and the challenge of equality. And this was also a theme that was already mentioned, but I will touch on it briefly as well. Reading through the book reveals that the litigation concerning the right to health can usually be conceptualized as focused on equality. Decisions to allocate national resources to certain medications and not to others are decisions that prioritize certain sicknesses over others. Decisions to limit the coverage of certain treatments also ratify the relevance of economic ability to the prospect to get better. In the same manner, once again, the decision to allow the operation of a market for medical services ratifies once again the relevance of economic ability. In fact, it is hard to imagine a right to health litigation that does not raise equality concerns as well. It is worth mentioning that this unbreakable connection between the right to equality and the right to health is especially challenging in the Israeli context, and I allow myself to touch on it here and there, because in Israel, as we may all remember, both rights, both the right to health and the right to equality, are derived from the basic laws by way of interpretation, which do not mention them expressly. And of course, this is not a barrier to recognize them, but this is a meeting point of two rights that are not expressly mentioned by the basic laws, and I think it's worth mentioning. My third point will touch very briefly on the issue of globalization that also cuts through the book. The present ability to move from one country to another is in a relatively easy manner makes the right to health a right that has global aspects. Private medicine is intertwined with the ability to go abroad and get the best medical services if this is necessary. In fact, the right to health is less local than many other social rights if we think about it. Since medical treatments are usually limited to certain periods, it is easier to get them abroad more than in the context of education, for example, which is more based on living in one place and on overcoming language barriers and other hurdles of this kind. This is on one hand, this is an important opportunity for people from less developed countries that can get medical services abroad. And at the same time, it is also a big disadvantage for local residents sometimes who have to compete with health tourism, like in Israel, for example, sometimes. In addition, waves of migration lead to the result that people who live in the same territory do not enjoy the same level of health services. For example, when migrant workers, even when enjoy coverage, do not get the same level of coverage as citizens, and I will also touch on the Israeli Supreme Court decision in this regard. My fourth and very brief point will be about the connection between the right to health and privatization. Another, I think, important theme, and we see in the title of the book that it is very much about the public-private divide as well. The everyday reality of the right to health is a microcosm of the many faces of privatization. In the area of health, the choice between private and public is not binary. It is not between a totally private system and a totally public system. The real question in this context concerns the level of privatization or private regulation. In Israel, the national health insurance lives alongside many manifestations of private medicine, some of them intertwined with the public health system itself. So as someone who's interested in the issue of privatization, I think this is a fascinating case study for the study of privatization, even for people who are less interested in the right to health as such. And my fifth point, and how can we avoid it, concerns the limits of litigation, which were already mentioned by Professor Daniels. The case studies presented in the book reveal that usually litigation succeeds in correcting specific wrongs with regard to the enforcement of health rights, rather than in introducing broad changes into the system. Aeyal Gross makes a compelling argument in this regard in the context of Israeli litigation. I think it is hard to disagree. However, I think this is just another example of the limits of litigation in general. Litigation is very important for the enforcement of rights, but we cannot expect it to change the system itself. This is probably even more accurate in the context of social rights that rely so much on complex bureaucratic systems. At the same time, litigation may lead to additional reform, so I suppose we cannot do without it as well. Some, maybe at this point, I will allow myself leave the book and maybe say something about the relatively newer cases of the Israeli Supreme Court, especially those that were not yet included in the book, maybe in the next edition, because of the gap, the time gap that Ron mentioned. So I will touch on two decisions that I will say that I had also the privilege of being part of them. The first case, and I'm mentioning them not necessarily in order to celebrate them, but rather in order to use them also in order to shed light on the challenges that we still have to face in the area of protecting the right to health. The first case I would like to mention is the conditioning of an additional supplement to the so-called children benefits in the vaccination of children. So I will not touch on this in a very concrete manner because we know that with political change in Israel, something that seemed to be irrelevant may be relevant again. I'm sure that some of you know that this used to be the policy and then it stopped to be the policy and it may be the new policy, but I'm not discussing the concrete case, but I want to present the example, the hypothetical maybe for our purposes of this linkage between vaccination and child benefits. And of course, there used to be a petition to the Supreme Court against this linkage between the two, the conditioning of the benefits in participating in some basic vaccinations that reflect the government's policy. And I will mention, and there were many arguments made in this context, because on one hand, obviously, mandatory vaccination is in many ways protects the right to health, the subject matter of our discussion. At the same time, there were arguments made about the fact that such a requirement infringes the right to autonomous decisions regarding vaccination, as well as rights to human dignity in the context of the support needed by children from from families who are in need of these children benefits. As we all know, I suppose the petition was dismissed by the Supreme Court by the three justices involved. I was one of them, and there were different reasoning offered, and I will not get into the details of the reasoning. It may also become relevant again. All I want to say is that we see here, I would say, another manifestation of the discourse around the right to health, because in contrast to what we see in the more typical litigation, when the litigants challenge the government for not protecting the right to health enough, in this context, the government is on the side of protecting the right to health, and the arguments that are made by the litigants are in some way that maybe the government protects the right to health too much. And we see here a different kind of balance. The right to health is not balanced against budget concerns as we see in the typical case, but we see a direct balance or a direct conflict maybe between the right to health and other rights. And this is, I think, a very different way of thinking about the right to health and its manifestation in the context of litigation. And I think this is a challenge for people who think about the meaning of the right to health in the public arena. The second case, the second and last case that I will mention involved the health insurance coverage of migrant workers who have lived in the country, in Israel, long periods, and I think this is the most recent big decision of the Israeli Supreme Court in the area of the right to health from last June 2014. I will just mention briefly that Israeli legislation distinguishes in this regard between citizens and residents on the one hand, and others with weaker attachments to Israel, migrant workers included, and this is the globalization aspect of the right to health that I mentioned previously. Whereas citizens and residents are covered by the national health insurance law, migrant workers are insured by their employers, who have to purchase for them insurance that meets the statutory requirements regarding coverage. A petition submitted to the court concerned the scope of protection given to these migrant workers, with an emphasis of migrant workers who live in the country for long periods, especially since the statutory terms stated that coverage should last only 3 months after the migrant worker is no longer able to work. The practical consequence of this term was lack of coverage exactly when the sick worker becomes needy and in the utmost need for assistance. The decision of the Supreme Court accepted the petition submitted in this matter and held that the lack of coverage of severe diseases after years of service constitutes an infringement of the right to health, and as far as I was concerned, also an independent infringement of the right to human dignity. At the same time, the decision did not invalidate the basic distinction between the regime that regulates the entitlement of citizens and residents on the one hand, and the entitlement of migrant workers in different ways. So the basic distinction is preserved by the decision. One might consider this an example for the limits of litigation. Others might see this as an example for the ability of litigation to bring about change while preserving space for promoting social change in the public arena as well. So we still have a way to go and think about these questions. So to sum up, and before the siren is heard, I would like to congratulate Aeyal and Colleen once again for this important achievement, and also to wish us all good health that will support many more future projects of this kind.